Hey, fans of freedom and open discussion, I'm heading over to Substack, and there's an ad-free audio and video version of The Adam Carolla Show that's going to be waiting there. In the near future, you'll even be able to watch ACS Live, unedited, as we record it, participate in the show via live chat. That'll be coming up very soon. You'll also get an ad-free version of the Adam Carolla and Dr. Drew Show. You'll also get an exclusive to my new podcast, Beat It Out, where I share unpolished ideas with my comedian buddies. The first series of episodes is going to be Jay Moore. You'll get all this and more for the low, low price of $9 a month, a pittance for all we're going to bring you. Subscribe now at adamcarolla.com/Substack, and I'll see all of you in our new speakeasy called Substack.
I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my nightmarish of a co-host, Brett.
Yeah, Alice, I don't know if I'm not marish, but what we're going to talk about today is nightmare-inducing. We just had a little run with AI. Tried to replace the show with AI version. It didn't work out.
It didn't work out maybe for the better.
I don't think we're going to be replaced. We're at least as podcast hosts. I don't think we're going to be replaced by AI anytime soon, but I don't know about as lawyers. Who can say?
So I know you guys have all seen all these reels on all the social medias. It's like, when is AI going to come for my job? And it's usually someone like a mom doing all the laundry and all the cooking, and we all laugh. But here's the reality. Whether we want to adopt it or not, AI is here, and it is, in fact, changing the way many different industries are operating, including none other than law. But there are ways that it can also make it be the most nightmarish of situations for any lawyer that can cost you your job, your bar license, and your reputation, which is, as we've talked about before, everything when it comes to the practice of law.
And if you've been paying attention to the news, you've probably seen that there have been a number of high-profile cases where lawyers have submitted briefs, draft orders that have become opinions. Oftentimes, a lot of you don't know this, but when you're an attorney, when you file something with the court, they often want you to attach a draft order, which I think is the stupidest thing ever. I hate doing it. If that's a local rule, I usually ignore it.
They want a Word document so they can edit it, but the editing is really just to take out the draft and then they sign it. And so essentially what you have is like both sides are arguing, one of them is like, the motion to dismiss is denied. And then the other party would submit something that's a draft order that says the motion to dismiss is granted. And then the judge picks which side. But when they're not one-line orders, when it has a little more substance, citations to why the order is ordering what it is, those are usually coming oftentimes. I think every court I've practiced in, state and federal, there is some requirement by the court that you email it directly to the court. So it's not on the docket for everybody to see, by the way.
Yeah.
A draft order, which I always thought was funny. I was like, no, let's put it all there. Let's put it all on the docket.
I think this is surprising to the lay person that so many judges' orders are written by the prevailing party.
Correct.
But it happens a lot. And this has been happening with AI. People are turning to ChatGPT or Claude or Grok or whatever your preferred AI friend is and asking it, hey, write me a draft order that says X, Y, and Z with citations to relevant case law. And you know how AI is so helpful. Sure, here it is. Do you want it in a Word format? And they send it to you and you're done. Your work is finished.
So why do we even have to be lawyers anymore when ChatGPT or Claude or even the legal research ones, I can't sign on to Lexis without them forcing me into their AI tool before I switch back into the Neanderthal version of the website to do my legal research with my hands, typing letters instead of having an AI tool just spit it out to me. Why is that, Brett? Because if you've ever used any sort of an AI open source or closed source product, you know that when you have a conversation with it, it sounds something like this. AI, draft me a contract saying I now own my neighbor's pool. Here it is. AI, can you make that sound more realistic and put in some more reasons as to why I deserve this pool? You're exactly right, Alice. Let me help you with that. And they're always going to agree with you. They are like the most affable, supportive cheerleader of a coworker you'll ever have. But what happens, Brett, when you have a coworker who's a yes man or yes woman all the time? Even when you're wrong or there's nothing to support what you want to do. And I just say, yes, sir, here is how you're going to get there. What happens?
That's when mistakes are made. And a lot of this reporting in the news, but you haven't gotten to see it until now. Some of you have probably seen this clip that we're about to play, but if you haven't, just prepare yourself, particularly if you're a lawyer, to the shudders of fear that will go through you as you watch
crawl
this.
Out of your skin. Everyone's worst nightmare. I have nightmares about this exact situation.
So this case, it's out of Georgia. It's Payne versus State of Georgia. It's the Hannah Payne case in 2019. Some of you are familiar with it. It's actually really interesting factually. We may want to cover it at some point. Just to give you sort of a rundown, there was a hit and run. This lady, Hannah Payne, shows up on the scene. There's some dispute about what the officer on the scene told her to do. But in any event, the person involved in the hit and run, they take off. She gets in her car. She follows.
Really quick and important fact. Hannah Payne was not the victim of the hit and run.
Yeah,
she just
a random
observed
person.
it. She's just a citizen who sees this person hit a car and then keep driving as opposed to stop. So she's not, by the way, a victim of the hit and run.
So she takes off. She chases this person. They eventually get out of the car. There's some sort of altercation, depending on who you believe. You know, maybe she was threatened, maybe she wasn't. But whatever happens, she ends up pulling out a gun and shooting the hit and run driver. He dies. She's charged with murder. She's convicted. An appeal follows. And the appeal is basically that the jury instructions were wrong, that the jury should have been instructed more on self-defense, the role of self-defense when it comes to a citizen's arrest, that sort of thing. They weren't. Therefore, you should overturn our conviction. As you know, when you appeal something, it starts in the lower courts and moves its way up. And I assume in Georgia, I guess it started at the trial level court. Maybe this is some sort of collateral review. I'm not entirely sure what the exact procedural posture is. But the important thing is the prosecution won in the lower court. They convinced the lower court, we're right. She shouldn't have gotten this.
She shouldn't get a new trial.
She shouldn't get a new trial. She shouldn't get the jury instruction. And, oh, you want an order? Here's a draft order laying all that out for you to sign. Court signs it, goes up to the Georgia Supreme Court. And this argument begins, goes to the end. We're only going to play you the very end of the argument because it is the most relevant portion. I'm going to play it now.
If there are no more questions.
So before you sit down,
Yes,
there's
sir.
one more thing I need to ask you about, unfortunately. In reviewing the trial court's order denying the motion for new trial, there are at least 5 citations to cases that don't exist. And there's at least 5 more citations to cases that do not support the proposition for which they're cited, including 3 quotations that don't exist. My understanding is that you prepared the order for new trial, the denial order for the trial court. Were those citations in the version of the order that you submitted to the trial court?
No, Your Honor, I do not believe so. They were not. I did prepare an order. That order was revised.
So those non-existent cases were cited in your initial brief opposing the motion for new trial.
Your Honor, I'm not aware of that, but I would be glad to research that and provide the court with a supplement.
Okay, we'll get a briefing order out directing what you need to supplement with. Okay. Thank you.
Thank you.
Mr. Fleischman, you have some rebuttal time left.
There's no way that motion's in that binder, by the way.
And she's not going to find the answer.
Okay. So what you just saw, let's break it down. So they're at the Supreme Court of Georgia, and they've gone through the substance of why there should not be a new trial or why there should be a new trial. And so this is the tail end. You heard where this clip began was she said, usually you end with, if there are no further questions, I reserve the balance of my time, or, I
Yield it back.
Yield it back. Whatever the whole point is, she's ending. The substance has ended. Probably what happened is there were questions. She's answered all of them. She has done her closing remarks there, and she's about to sit down. And that's where you hear a Supreme Court Justice, Nels Peterson, come in and say, you never want to hear unfortunately in a question.
Yeah.
Says, I have to ask you about something, unfortunately, and dives in. And here's the thing. This is what preparation looks like, because he gave her an opportunity, but I think he knew that she had no idea. And so he also researched ahead of time to find out the origin of the hallucinated citations, and obviously cited it back to her motion. If it was in her motion, then almost entirely absolutely true that it was in the draft order she provided to the court. And even if it wasn't, it was provided to the trial court, in which the trial court, if for some reason the trial court drafted it, he knows that she drafted it, relied upon her brief, which was based on hallucinated citations, quotations that don't exist, and saying that a case means something other than what it actually says. Those are all like first year of law school. You don't have to go to law school to know this. Each of them are absolute failures that could be career ending. And here we have maybe 13 situations of it. And you can tell that she's completely caught unawares. And she immediately denies it to begin with.
Guys, we are so happy to talk about Gusto today. You know that feeling when you finally clean out a junk drawer that's been bothering you for months? That's what switching to Gusto felt like for our business. Payroll, HR, benefits, all the admin chaos that had been piling up, finally organized in one place. Look, we love doing this show, and we are blessed by the fact that it has turned into a business. We have people who help us out in various areas, and we have to run payroll on occasion. And I will tell you, it is really confusing. Even for us, we're lawyers. We still don't entirely understand it. And that's why it is great to have a company like Gusto that can help us. Gusto is online payroll and benefit software built for small businesses. It's all in one, remote friendly, and incredibly easy to use. So you can pay, hire, onboard, and support your team from anywhere.
They have automatic payroll, tax filing, simple direct deposits, health benefits, commuter benefits, workers' comp, 401k, you name it. Gusto makes it simple and has options for nearly every budget. They also have unlimited payroll runs for one monthly price and no hidden fees or surprises. You can save time with built-in automated tools, offer letters, onboarding docs, direct deposit, and more. Try Gusto today at gusto.com/prosecutors and get 3 months free when you run your first payroll. That's 3 months of free payroll at gusto.com/prosecutors. That's gusto.com/prosecutors.
Okay, so a few things on this. Number one, if you're a lawyer and you practice in court, not all lawyers do, but if you do, you've had situations where you've had to argue something, maybe in front of a trial court, maybe in front of an appeals court. It is a nerve-wracking experience because you're being asked the questions. It's not like in a trial where you're getting to ask the questions to the person, and just the frustrating thing is getting them to say what you want them to say. You're being asked questions, you're being put on the stage, and you go through it, and there's that moment where it feels like it's over, and you kind of scan the judges' faces. They don't seem like they have a question. You do that whole line Alice was talking about, and you're thinking, oh, I'm about to get to sit down. That moment where he does that, I can't even imagine what that must have felt like for her. This is Chief Justice of the Georgia Supreme Court, Nels Peterson, who Alice and I both know. Like so many people that we know, far more successful than us. Seems like all our friends are more successful than us. It's just fine. Nice guy, super nice guy, brilliant guy, brilliant justice. Georgia's very lucky to have him, but he's In some ways, he's the person. If you have to be asked this question, he's the guy because he's not going to crush you. There are judges on the 11th Circuit where we practice where this would have been just an absolute devastation. I'll never forget this story. I'm not going to name names, but when I was clerking, I heard a story about one of the judges on the 11th Circuit. And the story goes that it was this judge's very first oral argument they had ever attended. And there's a panel of 3 judges, and this lawyer gets up, and he's very clearly nervous. And they start asking him questions. Well, at some point, this new judge starts asking questions, and he's asking tough questions or difficult questions. The guy's having trouble answering. He's starting to sweat and stutter, and the judge is just hammering him on this point. It's clear this guy can't answer. And the person who was telling me the story said, and all of a sudden, it was like all the color just drained out of his face, and he just fell backwards, and his head hit the ground. And when he hit the ground, it was like the sound of a walnut getting smashed by a hammer. So this dude is passed out under this judge's rigorous questioning. And the senior judge on the panel at this point writes a note and slides it over to this judge. And when he opens it up, it just says, no more questions. But that's the kind of thing that can happen. And I think I've told this story before, but if I haven't, my first oral argument in the 11th Circuit was before this judge.
I don't think I knew that.
Judge. Yeah, it was before this judge. And I had written this brief, and people are asking, like, how could this happen? How did she not know this? You got to remember, this order was probably prepared a year ago, 2 years ago. There's no telling how long ago this happened because it takes a while for things to get up through the court. So she may have forgotten that they even did this, may have never even thought about it, just assumed those citations were correct. Certainly doesn't remember doing this at this point. So I had this brief, and the lawyers I was against, it was one of those throw the spaghetti against the wall type things. And they had made this one argument that was so frivolous, I didn't even address it. Actually, I went to my boss and I was like, this argument, they said, this is terrible. Do I even have to get into this? And he was like, no, if it's that frivolous, you don't have to worry about addressing it. So I'm like, okay, I'm not going to address that. It's so frivolous, right? So file the brief, months pass, get an oral argument notification. It was a death penalty case, so we knew that was going to happen. Months pass, go to oral argument. They do their argument. First side argues, terrible, going to kill him. Got this, right? Stand up to start the argument. And this judge, the one who'd made the guy pass out and his head hit the floor like a walnut, before I can even say anything, before I can get my name out, he's like, counselor, why didn't you address this point? And it was the point they had made that I thought was frivolous. But at this point, I don't even remember that. I'm like, what in the world is he talking about? I don't know what he's talking about. I hadn't thought about this in months, right? And so I just say, well, Your Honor, I didn't think it was relevant. And he says, I don't only think it's relevant, I think it decides the case. And so then he's like ranting at me about this. And I'm standing up there trying to think of something to say. But the only thing I can think in the back of my head is, don't pass out. Don't pass out. Don't pass out. And eventually got through it. But it was a really brutal experience. And I can only imagine what this woman is going through when he's asking these questions. And she's flipping through that binder. Just buying time.
Just hoping. I mean, when I cut in and said, maybe the motion was in there, but unlikely. It probably was just the briefs that they had at the Supreme Court, right? Because it's already past that point. I think she was praying for anything to happen there, but that is the absolute worst feeling in the world. So being asked a question that you don't know the answer to happens to every lawyer. Being confronted in the midst of it that you have just delivered an answer that is inaccurate. I don't think she lied. I think she had no idea when she said, no, if it was hallucinated, it wasn't me. Like, don't blame me on it. And she is right. The order absolutely was edited from the version that she sent because the version she sent wasn't signed. You don't sign the order for the judge. That is not a lie per se. It is absolutely true. Any draft order that you prepare for the court, it is left unsigned and the judge does sign it. And they could do other things to it. You may not know, especially this order. It doesn't sound like it's a one-line order. There are at least 5 citations that are completely made up. There are at least 5 citations to cases that don't say what it is. So this sounds like a relatively long order. So I don't think she's lying anywhere there. She's thinking, of course, you can tell she's an experienced attorney. I think she's practiced for 27 years. I mean, this is actually a travesty to happen to any attorney. We do not say this lightheartedly because it is every attorney's worst nightmare. And unfortunately, you're seeing a lot of very experienced lawyers be shut down with this because you've done this so many times that you think hopefully they were reading it. I got this. I know this. Like I've done this so many times. I can do this in my sleep. And the problem is when you don't site check every single case. Now, this is what's really scary. You're supposed to essentially reread every case in a brief when you refile it. Because of how long these briefs can be, it depends on the order, but like for a very lengthy substantive motion, 30 plus pages is very common. And you are supposed to, best practice is you do that. But when you've been living with the draft and you've been reading the cases in different sections and addressing different arguments at different times, not everyone, I would say most people probably don't sit through before it's due to do a full edit and read every case as they're editing it, because those are two very different things that you're doing. One is a technical edit for like nits and misspellings and grammatical errors. And the other one is like a meaty, substantive thinking exercise. And to do both of those at one time is actually, I never edit both in that way. I usually have like a thinking version and then I have like a pure nits edit. All to say is everyone who is easily saying, she should have just read it. Yes. But in the olden days, before we had AI and we would draft briefs, there would be a practice where you've lived with a brief so long that your very last thing may not be to read all the cases in a brief. Now that we're in this new world of AI where we think, we should know by now that they do hallucinate. We think that what they're giving us is all correct. Human error plus AI error compounds in ways that are devastating like you see here.
And look, I think there's a cascade of ways to look at this. And I think the obvious, natural initial response is, I can't believe she did this. I can't believe she took this shortcut. She should have taken the time to do this. You can't file a brief with citation like that. And let me just say, that initial thought is 100% right. You can't argue with any of that. But I also think to the extent we're trying to avoid this happening in the future, that's not actually that helpful, because I think we need to think about why this happens. And it's not because she's lazy. So she is a prosecutor in state service. The fact of the matter is, most of your states, your AG's offices, your district attorney's offices are overwhelmed with cases. They have far more cases than they can prosecute. The ones they do prosecute, they then have a ton of appeals. The vast majority of the appeals are frivolous. They are trying to do good work quickly. It's a triage thing. I compare my current job to my job in the AG's office, which was kind of the opposite of this, because I was in the Solicitor General's office, which actually was better, even though the only thing we did was write briefs. Because they were really important briefs, we had a lot more time to write them. So I might have a brief a month, which isn't bad at all. Now, it would be a death penalty brief or a brief to the United States Supreme Court. So it's really important, and you got to read it 1,000 times, and you literally go through every single citation and read it again and check it again and make sure the pin side is exactly right and it stands for exactly what you say it is, and do all that and take a ton of time. And that's great, but I had a month to do it.
And that was it.
Yeah.
Your brain didn't have to do the loss of efficiency of switching cases.
Exactly. Focus on that entirely. My current job.
How many cases did you even think about today?
Oh, so many. I wrote a brief today.
Dozens, right?
Yeah. I wrote a brief today in an 11th Circuit case. I did research for an indictment with a really complicated fraud question that I was trying to figure out. I helped another attorney with their jury instructions for a civil rights case. Like, I did all this stuff today. It was like all over the place. And I'm filing a brief every week to the 11th Circuit.
And for what it's worth, Brett, as hard as he works, has it even better at the federal level where he practices than at the state level. Because remember what we've talked about, jurisdictions, all violent crimes really go to the state and local prosecutors' offices. So when you look at pure caseload numbers, the state and local DA offices will be factors more than your federal prosecutor offices. Both are very busy. Federal prosecutors are incredibly busy, but the numbers are just very different. And you can say, like Brett said, if you're spending more time because the complexity of it, maybe it's spanning multiple jurisdictions. These are trials that could go on for weeks, maybe months, whereas maybe you'll have more one day or shorter trials at the state and local level. But having to switch between and keep your brain around all your different cases. And this applies to private practice too. This is just to show you that this is not just public servants. Today, you bill on cases. Billing just means you work on those cases. I think I touched also about a dozen cases. I didn't spend an hour on each case, but it definitely I'm not a robot. So when I switch from one case to the next, I can't switch on and off right away. My brain has to recalibrate and switch from one completely different area of law to another one as I have to, say something brilliant and solve some crisis management problem at that point. So all to say is when you are told there is this tool that can help be your brain and help make you more efficient, not to replace your brain, but rather to give you the tools to make your decision, it sounds great, right? Like it's going to summarize the cases for you, and then you make the decisions of how to apply those cases to your facts or to the law in your area. But let me just, instead of you having to read 500 pages of cases, let me just summarize them for you, put them before you, and then you decide. So that sounds like an amazing tool. And in some ways, when you are so overworked in whatever practice you are, it seems like it's impossible not to actually continue to practice law at that rate when others are making use of these AI tools. And we've all been told, we have had millions of CLEs, it seems like, that all say top line, if you don't adopt AI, you will no longer be a lawyer. Like AI is not going to replace lawyers. Lawyers who don't use AI will be replaced. That's the same as in every industry, but there is some truth to that. And so without these parameters and without actually a good legal AI, because there's AI and then there's legal AI, this is how we create this problem here that you're seeing here. And by the way, she's not alone. There have been dozens of viral moments like this over the past few years that you've probably seen. She's the latest. This was in the last few weeks. She is not alone. And this is happening in jurisdictions, federal, state, district court, appellate courts across the nation.
And I saw a story, I tweeted about it last week, which blew my mind. So Westlaw is the gold standard. So if you go to law school, depending on whether you have a Westlaw rep or a Lexis rep, you get trained on one of those. But Westlaw's gold standard, the old books, when the court reporter was literally a book with cases in it, was published by Westlaw. Westlaw, that's what you use. That's what I use to do all my work. Westlaw tells me it's true, then I assume it's true. Westlaw now has an integrated AI research tool. And there was an attorney who used that tool, filed a brief based on what the AI tool told it, and the Westlaw AI had hallucinated cases.
No.
So,
and you know what's crazy about this and why it's so easy to fall into this trap? When you use legal research tools like Westlaw or Lexis, for the whole time we've learned to use it, in essence, there has been an AI tool built into it. And that's the flagging system. The yellow flags, red flags. If there's a flag by your case, it's supposed to indicate that it's been overturned or something within it has been challenged or overturned. It's not always true. Those of us who've grown up using it, we know that you can't just rely on the yellow flag or red flag or lack of flag. Sometimes when there's no flag, something has happened in another case and it has not been caught. So that is AI, right? Like it's helping you figure out where your legal research should go. But we all know it's supposed to be a flagging system. But they've had these tools all along. So you're supposed to be able to depend on lawyers creating this tool for lawyers.
And I'll tell you what the other issue is. This happened to a local law firm around here. So I write a ton. I write so many briefs and responses and everything else. And lawyers in the office, when they have an issue, often come to me and say, have you seen anything like this? And I usually send them 2 or 3 briefs. Say, yep, done winning on exactly that issue. I sent them the brief. There is no attorney in our office who is going to say, I better site check this. Like, I better make sure he correctly attributed this. No one's going to do that because they trust me. They assume that I'm going to do it right. We have a brief bank where there are all these briefs on all these different issues that have been filed before. And there was a case recently where some attorneys, they had a brief bank. One of them pulled a brief from the brief bank. And you got to remember, there's all sorts of different things used in law for that you have to talk about. And some of them are like inane. Like, why do I even have to talk about this? The court has jurisdiction because X. Here's a case that says that. We all know the court has jurisdiction, but you're making me cite a case, so I'm going to cite a case. Well, whoever wrote that brief and put it in the brief bank for that inane jurisdiction part that nobody cares about, had just said, hey, ChatGPT, what's a case that says they have jurisdiction? Oh, that one, great. Threw it in there and went. And they filed that brief over and over again. And because no one actually checks the jurisdiction section, because of course you have jurisdiction in this particular type of case, they filed it a ton of times in a ton of different courts, and no courts caught it until finally some probably first-year associate at some firm was responding and site-checked every one of the cases in their brief and realized that is a hallucinated case in their jurisdiction section. And then,
by the way, jurisdiction is everything.
No, that's true. But that's the crazy thing is there were 1,000 cases that said there was jurisdiction.
And it still did that.
Yeah, and it still did that. It could have picked one easily. And so then you're on the hook for that. And like this lady, we all assume she did this. We don't know that. She could have said, hey, Summer Associate, got a great,
or her paralegal,
easy thing for you to do. This will be great experience. We've won this case. Write up an order for me. And then now she's on the hook for it.
So, like we said, this really has just happened in the past couple of weeks. Ultimately, what happened is obviously she had no idea right now. Her boss, like the head prosecutor, had to come out with a letter and admit that she had used AI in this instance and that these were in fact hallucinated, and took the blame. And I don't know specifically what has happened, but I think in the letter, her boss said that she will be likely relieved from her duties or something along those lines. In other words, this is what happened. This was, in fact, AI mistake. And they did come out, and you have to come clean, because the thing with these hallucinated cases is you didn't miscite something, right? These citations are truly made up. And this is probably an incredibly devastating blow to her office. She's been a prosecutor for decades. If she's arguing at the Georgia Supreme Court, she's seasoned and well-respected in her office, and probably has done great work for a long time. And something as simple as AI hallucinating these cases very well could end her career, and certainly mar this incredible career that she's probably built.
And look, I hate this for her. And I think it's easy to laugh at her and jump on her. And I totally get it. I mean, it's legit major mistake, the kind of mistake that could cost you your career.
We all make mistakes, and
we all make mistakes.
And this wasn't this wasn't malicious.
So new.
This is
AI so new.
This is why I say, honestly, I've seen this with older attorneys. I actually count myself in that. So unfortunately, there are all these new protocols. Bar associations around the country are trying to figure out what to do that nobody knows. Because one of my jobs was trying to figure out like what all the different bar associations in the 50 states have AI policies. Nobody knows what they're doing. All the AI policies are probably written by ChatGPT. They don't make sense. They talk to each other. And essentially where it's come to, at least this is what I see in my practice, and I'm curious for other lawyers and other people in other industries, what they hear. On the one hand, I have everyone sending around clips like this, and people from the top down, and also clients saying, definitely never, ever, ever, ever use AI, because this will never be us. This will lose an entire case. It will ruin your career. Never do this. We pay you for your brain. Don't use AI. The same client, the same bosses will also say at the same time, make sure you use AI so you're not inefficient, because our clients aren't going to pay for inefficient uses of time. So if you're sitting there doing a 50-state survey, we're not paying for that, because you should just be using AI in order to do that type of research for you. So this is actually really confusing, because I will probably say that not just the legal industry, but many industries are getting both arguments thrown at them. And you kind of end up like this sometimes.
So here's my advice, and I'll be interested if Alice has advice as well. And I guess we'll just talk about, this was going to be multiple topics this episode, but I think we're just doing AI.
I was going to say, this is super interesting.
Yeah, this is super interesting. So here are my thoughts on how to use AI, because I use AI, but the way I do it, so I would never let AI write something for me, because come on. I love M dashes.
Except for our April Fool's episode.
That's true. It did write that. And look how that turned out.
It was terrible.
So I love M dashes. I can write my own M dashes. I don't need AI to do it.
I really am sad that's an AI thing, because I also like M dashes, and now I can't use it because people assume it's AI if I use an M dash.
I saw an article and it was like, the one word that tells you it's AI. It was moreover. And
no, you use moreover all the time.
Moreover's a great word. What are you talking about? Anyways.
In other words, what they're trying to say is if you try to sound smart, Brett.
Yeah, you'll be AI. Okay. So, but if you're a lawyer out there, or really anybody out there, number one, write your own stuff. I think you should write your own stuff, do your own thing. Now, one option you always have, and what I always do, number one, AI is a fantastic copy editor. Really good at that. I don't know if y'all saw this New York Times story where the headline was a North American treaty organization without America, ? And everybody's like, it's the North Atlantic Treaty Organization. And it's like, oops, if they had just ran that article through ChatGPT, it would have said, by the way, you got the acronym wrong. It's Atlantic, not American, right? So when I do stuff, I write the whole brief myself. Then I take the brief and I give it to ChatGPT and I say, hey, check this for errors.
How do you do that with a closed? Because that's open, right?
Well, so I have like a...
Do you have filters
I have
on
the...
I mentioned this to other people because this is actually a really interesting point too, because of using open source AI is a problem when it comes to attorney-client.
I've got the membership.
No, I'm pointing you out for this. I'm actually pointing it out for everybody else in case they're like running to just an open source. If you're an attorney, there are, and we've seen, well, there's very interesting cases that we should probably cover on this case in terms of AI generated documents or things run through AI piercing that attorney-client privilege veil. So,
and everything I give it, I'm going to file anyway. So it's all going to be public. So like, it doesn't
I'm
matter.
not pointing you out.
Alice is right. If you're doing like a confidential memo with a client, maybe don't send it to AI. Though I disagree with that opinion. This is a totally different thing.
That opinion I think is completely wrong.
That opinion is completely
wrong. And it will be
wrong.
wrong as you see practice. You can absolutely use it to summarize things.
My search is in Westlaw.
As long as it's in furtherance of asking for legal advice. Because it would kind of be like me going through a translator. Right? Like,
and
help
Alice
me.
and I are talking. This is inside joke because we haven't explained to you what happened. There was a court in
What's the case
New
name
York.
again?
It was Judge Rakoff who did it. I can't remember the case.
I was just talking about this case
Judge
today.
Rakoff's brother was my property professor.
Hold on.
So Judge Rakoff said that anything you ask AI is no longer work product and doesn't have attorney-client privilege.
Hepner.
Now, it was a little more confusing that because it's like a client did it and then sent it to the lawyer.
Right. It didn't say it was so it's United States versus Hepner. Essentially what happened in that case is the client summarized like the facts of their case through an AI, like a chat GPT, and sent it to their lawyer. And they said that was not attorney-client privileged because it came from that. Now, a lot of lawyers got scared because while it didn't say specifically that was the client rather than the attorney doing it, and there's still an argument that if the attorney did it, then it's still attorney-client privilege. But obviously, I think that's wrong though, because it's essentially working with a translator or a compiler. Like if you dictaphoned it and sent it over, no, that's absolutely attorney-client privilege. Like if my hands hurt, I have rheumatoid arthritis, and I'm going to dictaphone my entire story and send it to my lawyer, that's fine. And that's essentially what the new age dictaphone is for purposes of that.
That's Judge Rakoff for you. He loves doing that kind of stuff.
I know.
He's one of those judges. He likes to be on the cutting edge or whatever.
But anyways, that's the Hepner case. You should be aware of that case because everyone's talking about it. I don't think it will actually be I think in practice, it will quickly prove to be unworkable. And it's a SDNY case, so it's not applying to like the entire country.
Before Alice accused me of violating
attorney-client
privilege, I was continuing. So you can give it your brief or whatever you write and ask it to point out errors. Now, the thing, never let it touch your brief. Like, keep your own file, because if you ask it to like touch up your brief for you, there's a chance it will introduce hallucinations. Yes. So you gotta be careful. Don't let it touch your actual brief. But it'll give you a list. It'll say like, on page 3, you forgot a comma. Or on page 4, you called it the North American Treaty Organization, the North Atlantic, or whatever. So that's good. Now, I will tell you, when it comes to site checking, it's terrible.
It is terrible.
It's awful. I asked it today. I was doing that research. I'd done all the research. I'd found what I found. I was like, you know what? I'm going to see what ChatGPT thinks about this. And so I was like, hey, ChatGPT, what is the answer to this question? Give me some cases with citations. And it was like, this is very clear, because it's always this is very clear. And here are some cases that support the proposition for X. And it gave me like 10 cases. 3 of them were maybe on point. 7 of them had nothing to do with it. They all existed. I'll give it credit. It didn't make up any cases, but 7 of them had nothing to do with the question. And the 3 that it came up with, I'd already found. So it wasn't even that helpful, but you just cannot trust it at this point. And I have a subscription, so I'm not even using the basic one. I'm using the more advanced one. You cannot trust it. If you're a lawyer, if you're a professional, you cannot trust it to do the work for you. It can maybe check for you. It can maybe do basic research for you, but you got to review everything it does. It doesn't even save much time because you have to spend so much time making sure that whatever it told you is true.
So I'm probably on the other end of the spectrum. I am so scared of using AI because of what has happened to this attorney here. So I use it much less, not because I don't want to, but because I'm so risk averse and I want to be the attorney who, if I'm asked, did you use AI on this? I can honestly say, not even a little, not at all. But with that said, the things that I feel I can use it for, I never let it touch my briefs, just like Brett said. I never let it touch anything that will go out, including emails. I know a lot of people are really into letting AI draft their emails. I write all my emails. So all those typos, mine. I don't expect any communication in my practice, whether it's filings or emails, because a lot of your communications happen in writing, even if it's not filed briefs with the other side or your clients. I don't let AI touch it. But when I want to know, say I'm starting, the law is all about learning things anew. We're experts at nothing, right? It helps me get from zero to at least a starting place to be able to understand the historical procedure of where I am. So if I'm dropping into a new case, say I've never done cryptocurrency before, and I really want to understand, like, how have we gotten to where the state of the law is today? I may ask for like historical timeline of what's happened to help point me to the relevant touch points within it. That's how I use it. And then if I have to read, I have it summarize cases for me. That has not been great, but this is less so for writing a brief and more so for the other side has cited like a million cases and I want to know what categories they fall into. So again, honestly, I use like paralegals more because I trust them.
Well, I'll say this, and I try not to be full of myself because that's not good, but I'm like the best researcher.
You really
in the
is.
world. When it comes to the law.
He is so good. There's a reason everyone goes to Brett at our office.
And it always worried me because I was like, the only thing I'm good at is research. Like I can find cases faster than anybody.
How do you do that, by the way?
AI is going to ruin this for me. Nope. I'm still good. It may replace me eventually, but not yet. I'm still good. Just like our podcast will continue despite AI. We're still good for now.
You saw what people said, though. You can be replaced. I just can't be replaced because my voice was terrible.
That's true.
We just have to pay $2,000.
It would have been funny. I kind of want to go back and see what my voice would sound like.
I was going to say, yours is almost too good. Like
it is almost too good.
It's not almost too good. It is too good, but yours is the more obvious one that people would be like, that's not his accent. It would be so disconcerting to hear yours bad because I don't really have an accent.
You know what one of the giveaways was?
Of you?
The breathing.
That there was no breathing?
No, there's tons of it. It adds a breath before basically every word. Like if you listen carefully, you can hear us breathing.
Is that how they make it sound realistic?
Much. They're trying to make it sound realistic by having the breath sound of you breathing before you make a statement. There's so much more breathing in that episode.
There really was a lot of breathing. Done. People probably say misophonia here.
Yeah, I mean, it's funny. Yeah, it did a lot of it. Anyways, we don't have answers for this. If you're a lawyer, everyone will offer you CLEs on AI. If you have to pay for it, I don't know that it's worth it, to be totally honest. I've watched several of them because we're required by all these different bodies to watch them, and I have yet to watch one that's better sent an email
than what we talked about today.
Well, it's funny. Somebody sent an email with a business plan generated by AI
about how we should do CLEs. I've already told you this, that if we quit our jobs and I had time, we could just make all of these legal briefs CLE episodes.
We had this one company who reached out to us to do a CLE, and we told them how much we'd charge, and we never heard from them again.
It wasn't even that much. I don't remember.
It wasn't even that much.
It really wasn't even that much. Unreasonable. Yeah. In fact, they raised it. I I think we just accepted.
We upped it a little bit more than they said.
But
just
they were like, what about this? I don't remember the amount anymore, but we were like, well, just a little bit.
We made a counter offer, and they were like, never talk to them again. It's funny.
And we're like, fine, people can get it for free on Apple Podcasts anyways. I've attended CLEs that have much less law than what you're getting here. Anyways, we were going to talk about 3 different things. And as usual, we've gone an hour on this. So bottom line is this is obviously continuing to develop. If you use it / I think everyone will end up using it at some point. Figure out how to do it responsibly. Protect your integrity if you're a lawyer. Read the cases. Don't trust them for case sites.
Just
don't assume they are all hallucinated citations.
It is not the end of the journey. It might be a tool, but it is not the end. You can't let it be the end. If you just check everything it says, you'll be fine. But you've got to at least check it. Even if you're going to save time, just check to make sure it's accurate. Anyway.
Well, guys, I hope this has been entertaining and in the sense of scaring the crap out of you. You know, things that this new generation is going to talk about. They're not going to talk about singularities or, you know, the Bermuda Triangle or quicksand. They're going to be like, if I turned into a cat on a Zoom call, or if my brief had AI hallucinations. But let us know what you think. You can email us at prosecutorspod@gmail.com. We love covering topics that are timely, that you find interesting as well. Today, we only got through one. So maybe come back tomorrow. Maybe we'll have more to talk about. We definitely do. But until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. This is exactly why and it's not good. It has like a massive chilling effect on me. Me specifically. Not anyone else. I'm just like very risk averse.
I mean, it's just terrifying. Like I have like... It's
absolutely terrifying. I was just telling someone today that... Yeah. I mean...
Hold on. No, I'm taking forever. Hold on. Where are you? I can't find you.
I'm here. I'm here. Can you find me on the screen? I'm here.
I've lost you.
Oh no, I'm here. I can see you just fine for what it's worth.
Okay,
hello.
Hold on. Okay, let's... Sorry, I'm still...
TV has thousands of free movies and TV shows.
We're coming at you with everything we got.
This is the mindset. Free. This is the mantra. Free. This is the mindset. With movies like Pineapple Express, the entire Star Trek film franchise, and Gladiator, and TV shows like Survivor, SpongeBob SquarePants, The Fairly Odd Parents, and Ghosts, Pluto TV is always free. Huzzah! Pluto TV. Stream now, pay never.